I'd like to welcome everyone here to our webinar regarding underinsured motorist protection cases. My name is Barry Penner. I am the Managing Director of the Vancouver International Arbitration Centre. And you'll notice on our screen, I'm joined by a number of esteemed counsel, and I'm pleased to have them here. And I will introduce them all in a moment. But first, just a little bit about us and the Vancouver International Arbitration Centre, also known as VANIAC, which is our acronym. You may remember us as the British Columbia International Commercial Arbitration Centre, which was our name for many years. We were established in 1986 as a joint effort between the British Columbia and federal governments as part of a push to make Vancouver an international financial center in relation, it coincided with Expo 86, if any of you remember that remarkable event. So it was part of a government initiative, quite a conscious effort to help further develop Vancouver as an international financial center by having a world-class arbitration center. And at the same time, arbitration legislation in Canada and British Columbia was updated, modernized significantly to meet international standards. Fast forward to today, our name was changed about 2 years ago to Vancouver International Arbitration Center. Streamlined name, but still carrying on many of the same functions, only a few more that we did a few years ago. With the new Domestic Arbitration Act in British Columbia that came into force in September of 2020, we are now also an appointing authority under legislation. So where parties cannot agree on an arbitrator, rather than traipsing off to BC Supreme Court to have them fulfill that function, the Vancouver International Arbitration Center will play that role, helping alleviate some of the pressure on our court system. And in that vein, that's much of what we do. Increasingly, we see in commercial cases, parties, when they're entering into contracts, contemplate the future and want to avoid court if they can. So typically are now, or more and more often, are including arbitration clauses and designating VANIAC as the body to administer any potential dispute that might arise. With that said, for many years, we have been also handling underinsured motorist protection cases by virtue of legislation regarding ICBC and applicable regulations. So that brings us to the purpose of our discussion today. Notwithstanding legislative changes that went into effect in May of 2021, we are still handling a significant number of underinsured motorist protection cases, and we anticipate that we will yet for years to come. So practitioners in the area of personal injury law need to be familiar with matters pertaining to UMP cases, the acronym for underinsured motorist protection, and that's probably why you're tuning in today. So with that, enough about us. I should also say in the background here, helping us, none of this would be possible without our Deputy Director, Ina Ergashiva, who you may not see on the screen at the moment, but trust me, she's an omnipresent personality. She's helping pull this together today, and appreciate Ina's help. And if the computer seizes up, we will be calling on her for immediate assistance. With that, I'd like to start introducing our esteemed panel for today. Rose Keith, QC, is an associate counsel with Harper Gray with over 25 years of experience in a fairly broad civil litigation practice. Rose was admitted to the bar in 1993. Her litigation practice has included personal injury matters relating to underinsured motorist protection claims, defamation, misappropriation, contractual breaches, and sale of businesses. Her commercial litigation experience has exposed her to a broad spectrum of matters, including real estate disputes, shareholder and partnership disputes, injunctions, fraud, and product liability litigation. She's involved in a number of professional organizations, in addition to being a panelist on our roster of arbitrators at the Vancouver International Arbitration Centre. She's involved with the Canadian Bar Association's Government Relations Committee. She's a member on the roster at the Mediate BC. She's involved with the Trial Lawyers Association of BC as a board member, and a number of other entities and organizations as well. So she's a busy person, and we appreciate Rose taking time to be with us today. Next, I'd like to introduce Mark Tweedy, who was called to the bar in 1982 in British Columbia. He has practiced civil litigation for over 30 years with a practice devoted to mediation, arbitration, and adjudication since 2014. Mark received his Chartered Mediator designation in 2017 and a Chartered Arbitrator's designation in 2020. Mark has mediated in excess of 1,500 civil claims involving family businesses, personal injury disputes, professional liability, construction, aviation, insurance, including property, casualty, life, and disability, shareholders and joint venture disputes, real estate, employment, wills, and estates. His arbitration experience does include underinsured motorist protection claims and commercial, construction, and insurance disputes. He has also a substantial experience sitting as a court-appointed adjudicator in class action matters. Mark is a volunteer with and a board member of the president of the BC Lawyers Assistance Program, assisting in interventions, acted as counsel to lawyers in discipline, credentials, and practice standards matters before the Law Society of British Columbia, and has acted as a peer counselor to other lawyers. Next, I'd like to introduce you to Vincent Orchard, QC, who is a litigation partner at Borden, Ladner, Gervais, BLG, at their Vancouver office. At least he was. I think he's now retired from there in that role. We'll let Vincent clarify. But he was admitted to the bar of British Columbia in 1976 and is a graduate of Dartmouth College and the University of Manitoba. Vincent started his career at the Department of Justice in Vancouver before joining Ladner Downs, and is a former Supreme Court of Canada law clerk. He was appointed Queen's Counsel in 2004 and has numerous decades of experience in resolving disputes, senior counsel managing major litigation files for international and national corporations and public bodies, and has appeared as counsel at all levels of court and tribunals in British Columbia, as well as the Supreme Court of Canada and the Federal Court of Canada Trial Division and the Federal Court of Appeal. Moving to Mr. Glasner, Kenneth Glasner, QC, is an experienced mediator and arbitrator based here in Vancouver. He has practiced as a neutral since 1967 and was appointed as a federal Queen's Counsel in 1990. Ken has been involved in hundreds of disputes over a range of civil matters as a neutral and has been a frequent lecturer and panel member speaking on subjects dealing with alternative dispute resolution and designing mediation systems in Canada. He sits on discipline panels as well. A number of his papers have been published. He has retired as of a number of years ago as an adjunct professor of law at UBC's faculty of law. Ken participates with other colleagues as a special adjudicator and judicial justice of the peace, and a successful small claims project for the Provincial Court of British Columbia that resulted in the clearing of a backlog of cases. He's also on the International Institute for Conflict Prevention and Resolution panel of distinguished neutrals based in New York. He's a former trustee of board member of the Vancouver International Arbitration Center and a member of the working group dealing with domestic arbitration for the Uniform Law Conference of Canada. Recently, the Minister of Justice for British Columbia appointed him to an arbitration advisory group. And we have a late addition to our group. I'd like to welcome Alistair Burnett, who's a lawyer who's been practicing with ICBC as counsel for more than 20 years. He's currently with the Knowledge Management Department at the Insurance Corporation of British Columbia, called to the bar here in British Columbia in 1995. And has been involved in numerous jury trials and arbitrations, and has a significant depth of experience and a perspective that he brings from his role with ICBC. We will call upon Alistair as required, and certainly invite Alistair to make comments wherever he thinks it's appropriate to help facilitate our discussion and help better our understanding of matters pertaining to underinsured motorist protection cases. Just before we get started, I'll note that this session has been approved for continuing professional development credit with the Law Society of British Columbia. Just give us and the Law Society a couple of days to get that up on their website. But by next week, I think you should be able to log in and record your hours. Don't forget to do that, because before you know it, you'll be wondering if you have enough credit by the end of the year, if you're like me. So with that, I'd like to turn things over. Oh, by the way, if you have questions, please just note them in the chat function, and I will attempt to moderate those questions and direct them to the appropriate panelists. With that, who would like to get started?
I think I'm going to kick us off, Barry.
Thank you.
Okay, thanks for the introduction and thanks for inviting me to participate on this panel. I'm going to be providing just a bit of a general overview of UMP arbitrations. My co-presenters will be going into more detail on specific aspects of arbitrations, and Vince will be dealing with entitlement to arbitrate and various aspects of coverage. I'm going to be talking more about the process itself. So the reason, of course, that UMP claims go to arbitration is because of Section 148.2 of the Insurance Vehicle Regulation, which provides that any questions related to underinsured motorist protection falls within the jurisdiction of the Arbitration Act. The fact that it falls within the jurisdiction of the Arbitration Act makes it a different type of claim than pursuing a claim for damages in the civil court system. And I would encourage everyone to view it that way. This is not just a Supreme Court trial being held in a different place, although Alistair and I had a brief discussion about this beforehand, and I think he may disagree with me. But there are specifics to arbitration, the Arbitration Act, and the VAN AIC rules that are different. And as counsel acting on these cases, I would encourage you to be familiar with the Act and the rules, and in particular to check out the VAN AIC website, as it has a wealth of resources. You can access the Act there, you can access the rules, and they also have some helpful flowcharts which explain the process of an UMP arbitration. So in general, in my observation, the inclination of counsel is to run an UMP arbitration in an identical way that they would run a personal injury trial at the Supreme Court. It can certainly be done that way, but I would encourage counsel to rethink this and to take advantage of some of the provisions of the Arbitrations Act and the Center's rules, which can really decrease the time and cost associated with an UMP proceeding. The advantages of an UMP arbitration, from my perspective, really start with the ability to choose your arbitrator, and in particular, to choose an arbitrator with familiarity with UMP proceedings. This makes it very different than a court proceeding where you simply get a judge assigned to your case who may or may not have any familiarity with the UMP cases or personal injury cases at all. The other thing that happens in an arbitration is your arbitrator is involved from the outset. So when you start the arbitration, right away, you're going to be involved with the arbitrator, and that can really be used to your advantage to manage the process and to keep it on track and as streamlined as possible. And as a party to an UMP arbitration, you get to decide the process, and you can choose a process that is appropriate for your circumstances. For example, consider whether witnesses will give their examination in chief orally or in writing. And I know as a civil litigator, that's a very odd concept, but there are significant advantages to having the testimony given in writing. Arbitrations in general, in my experience, proceed at a different pace than a Supreme Court action. The communications with the arbitrator are much less formal. Typically, they're via email, and there's no need to bring a formal motion or go through all the steps and delay associated with doing this. An UMP arbitration is commenced by delivering a written notice to arbitrate to the center and payment of the commencement fees. And this is found in Rule 5 of VAN AIC's rules. The notice to arbitrate is Schedule A to the rules. There's a number of things that it includes, many of which will be familiar to those practicing in a civil litigation sort of arena. First of all, the names of the parties and counsel, as well as all addresses for delivery, a brief statement of the matter in dispute, a request that the matter be referred to arbitration, and a reference to the basis on which it's being referred, which in the case of UMP arbitrations is of course Section 148.2 of the Insurance Vehicle Regulation. It also includes a statement of the remedy sought that you're seeking, including an estimate of the amount, which is very different than what we do in court proceedings. You get to choose the number of arbitrators. It's usually 1 or 3, although the default position is a single arbitrator. I can't see a reason why in an UMP arbitration you would have 3. There may be something I haven't thought of, but I think typically you would just use 1. And the parties have a very broad discretion in deciding how to appoint an arbitrator. In practice, it's either done by agreement of the parties or by the appointment of an arbitral organization such as VAN AIC, which Barry already alluded to. If done by the center, what that process looks like, it's found in Rule 8 of their rules, is you apply to the center to have the arbitrator appointed, and you provide the center with the names of arbitrators previously considered by the parties. The center then provides a list of at least 4 names to each of the parties of the proposed arbitrators. And then each party lists in order of preference the proposed names and any names to which they object. And from that process, the center can then appoint, or they can deliver a second list of names and go through the same process. The parties can specify the required qualifications of the arbitrators if there are any. And also in the notice to arbitrate, you're going to include whether there's any modification to the VAN AIC rules. Most often in UMP arbitrations, we see the parties saying that the BC Supreme Court rules will apply. And again, I'm going to encourage everyone to really consider this. For example, do you want the limits on the number of experts? If the BC Supreme Court rules apply, then the evidence in chief of the witnesses will be by way of oral testimony, which is different than what would normally happen in an arbitration. Do you want that? Like I said, there are advantages to having the testimony be in writing. It replaces oral discovery, which reduces delay and costs. It, in fact, almost ends up being like the depositions that they have in the States. You have notice of the testimony of all the witnesses. It reduces the amount of time that you're going to require for your hearing. And it, of course, gives you a lot of advance notice of what the evidence is going to be. The witness statements in an arbitration are different than will say statements. They should contain a full and detailed description of the facts and the source of the witness information. And remember, if you are going that route, that they are to serve as that witness's direct evidence. Hearings proceed generally in person, but they can be virtual. If you are using witness statements, you tender the witness statement and then it's entered as an exhibit, and then the witness is going to be cross-examined. The hearing itself looks a little bit different than a Supreme Court trial. You don't wear your robes, and rather than a courtroom, you're generally in a boardroom, the arbitrator sitting at the head of the table and either party on either side. Practice may vary, but what I've experienced is that the proceedings generally occur with the parties being seated, which for counsel who are used to doing Supreme Court trials, that can be really not so comfortable. And of course, it's okay to have a different setup and where you're standing, but because it's not in a courtroom and it's in a boardroom, unless you've made arrangements for it, you're probably going to be proceeding sitting at a boardroom table rather than standing up as you're used to. In my experience as an arbitrator, I find it very useful to have the expert reports provided to me in advance of the hearing, as well as the witness statements and the arguments. My personal preference is to receive things in an electronic format, but you'll want to check with your arbitrator and seek guidance from them on what they prefer. That's about all I've wanted to say on process. I'm going to turn it over to Vince now, who will talk more about the specifics of entitlement to proceed to UMP and various aspects of coverage.
Thank you, Rose. Good morning, everyone. I am Vincent Orchard, and I'm professionally a lawyer, mediator, and arbitrator. And before I start my remarks, I just wanted to give you a bit of personal history, and in the context of the ICBC regime as it's changed over the years, and as I was listening to the introduction of my bio by Barry, the only thing I got out of it was, man, that guy must be old. But you know, I don't feel that old, but I am retired from my practice as a civil litigator for the moment, anyway. Just as a background, my personal injury and insurance litigation practice began shortly after the then NDP BC government in the mid 1970s introduced auto plan and incorporated ICBC as a crown corporation to run it, and introduced a mixed tort and no fault system of universal compulsory coverage. And it was based on AutoPac out of Manitoba and SGIO out of Saskatchewan, which also were introduced by NDP governments of the day, essentially to replace private insurance companies in the automobile insurance world. And now, ironically, I left my PI, personal injury practice, and insurance litigation practice a few months before another BC NDP government in 2021 ended auto plan as a mixed tort and no fault system to go with essentially a no fault system with minor exceptions, again following Manitoba and Saskatchewan. So I had about a 40-year run of litigation for and against ICBC. I've been involved in UMP claims since shortly after UMP became part of auto plan as a extension or optional insurance in 1984. I've acted as counsel for claimants. I've acted as counsel for ICBC and UMP matters, and I've arbitrated UMP claims. I've mediated them, and currently my experience with UMP is limited to mediating UMP claims or acting as an arbitrator. And above all, my goal today is to flag for you, the practitioners, landmines to avoid if your client has a potential claim. And I hope to highlight what should be front of mind for the practitioners in pursuing an UMP claim, or to use another metaphor, to assist you in navigating an UMP claim without coming to grief on the rocky outcrops of Part 10, Division 2 of the ICBC regulation, because there are some hidden landmines in that legislation. So I will touch upon the essential nature of UMP insurance coverage. That will be brief. Secondly, I'll briefly cover the history of UMP as part of auto plan over the years, and what may or may not be left currently after May 1st, 2021. My main topic, and the most time I'll spend will be on what triggers entitlement to coverage and what are the limits, exclusions to coverage, including specifically deductibles and limitations on costs. And if I have time, I will briefly mention a legal issue or two involving entitlement and excess UMP. So just to start with, in terms of the essential nature of UMP coverage, just remember UMP is first party coverage. And in that sense, it's more like, for example, Part 7 benefits, or more like LTD insurance. The compensation it may provide is purely contractual and statutory. And its coverage is defined and limited to Part 10, Division 2 of the regulation. So if you think your client has an UMP claim, my advice to you is to read it and reread Part 10, Division 2, the UMP provisions. Read that regulation, and it's varied over the years. So you got to make sure you got the right corresponding regulation to the motor vehicle date. But the regulation, or the copy I have, is only 8 pages long, so it's not terribly long. Historically, there have been 5 major changes since 1984 of the regulation and UMP coverage. And it's not like third-party limits, which are triggered by the concept of indemnity for a tort claim and combined with third-party action. third-party claim, you can have a direct action against the insurer. That's not what this is. This is first-party coverage. And so I've recommended you read the regulation. I also recommend you read Chapter 8 of the BC Motor Vehicle Accident Claims Manual, which I have edited for the last 2 editions. It gives you a lot of pretty obscure law that is very difficult to find, particularly pre-2007. It's only been since 2007 as ICBC in any systematic way collected the arbitration awards. So finding arbitration awards pre-2007 is a tricky proposition, but a lot of the important ones are covered in Chapter 8 of the Motor Vehicle Claims Manual. Now, I just want to stress, UMP is intended, subject to the express provisions, only limited additional compensation when an insured, as defined, and that's important to entitlement, suffers loss or damage for which an underinsured motorist, and that's an important defined term for entitlement to coverage, is legally liable. And it's been described by arbitrators as insurance of last resort or top-up insurance. It's not, I'm quoting one arbitrator, it's not intended to provide complete indemnity nor to be a substitute for the defendant's inadequate liability coverage. So now, turning to a brief history of UMP coverage, I won't go through some of the earlier versions, but in 1984, it started off as extension insurance, which was optional. Just you paid a premium, and it was limited to third-party limits. And then in 1992, that changed to include a mandatory UMP as part of basic insurance. And for a while there was a $2 million limit. And then in around 1993, there was the third regime, which combined basic mandatory coverage of $1 million with extension insurance to $2 million. And it's in the area of excess policies where there's a lot of tricky business going on. So you've got to find those, you got to look for those excess insurance policies, and you got to read them. And ICBC has not kept very good, or doesn't seem to have very good record keeping for those excess policies, and individuals sometimes don't as well. So that's important to flag, because the definition of insured in terms of occupants of a vehicle is changed in those excess policies that are issued under part 9 of the part 9 of the regulation. And there's what's called an APV 334 and an APV 334D. So you have to hunt for those to make sure you're doing the proper job for your client. Now, in 2017, there was another regime that expanded optional coverage and changed coverage attaching to vehicles as opposed to persons, and the expanded optional coverage beyond basic was up to 5 million, not 2. And then you have the final regime, May 1st, 2021, which we had a little bit of a discussion before the webinar got started, and the current regime, well, it's my view anyways, that since tort claims, with very limited exceptions, have been abolished in BC, there seems to be no point to UMP coverage anymore. Of course, UMP coverage continues to be available for MVAs, which predate May 1st, 2021. So that's where those will continue. And post May 1st, 2021, basic auto plan still provides 1 million UMP coverage for what it's worth. And ICBC offers a non-owned separate policy. But in what circumstances that coverage may apply is anybody's guess. ICBC's website refers to off-road or highway vehicles. So, others have a different point of view, but that's my view. The era of UMP as known before May 1st, 2021 is over, dead, end of story. That parrot is dead. But again, others may have a different view. So let me talk about entitlement, which is the most important thing I can probably talk about. And the two prerequisites to entitlement, one of which is meeting the definition of insured. I won't quote that now, but the definition is contained in the regulation 148.11. Again, I'd remind you that with excess insurance, that definition of insured may well be different. So have a look at that. The other prerequisite is that there is a underinsured motorist as defined, again in the regulation. It's a defined term, 148.11. And case law and court cases and arbitration awards establishes essentially that a claimant must prove, unless otherwise agreed with ICBC, an unsatisfied judgment. So if you have there's a claim to say down in Washington State, and formally you can proceed to get an unsatisfied judgment, and you will bring that back and have your UMP claim. But, and this is really important, don't think that as counsel for the claimant can just go off, settle for whatever minimum limits or maximum limits the insured in the foreign jurisdiction may have, or indeed in BC, and sign a release, and then come to ICBC and say, okay, I've settled the claim for the third party limits. Now I want to proceed to UMP. If ICBC has not waived the requirements for an unsatisfied judgment, in other words, to prove there's an underinsured motorist who can't pay a judgment, then the claim ceases to exist. So, word to the wise, if a claimant is contemplating a settlement with a third-party liability insurer for third-party limits, to do so without ICBC's consent results in no liability on the part of ICBC for UMP. The claimant cannot satisfy the definition of an underinsured motorist. Also, if you consent to a dismissal, and I obtained, I was involved in a UMP arbitration that confirmed this, that if the claimant consents to a dismissal of the tort action and signs a release of the tortfeasor, that ends any UMP claim. So the only safe course to preserve an UMP claim is to A, proceed to obtain a judgment, or B, obtain ICBC's consent to a settlement of the tort action, and that the liable defendant is an underinsured motorist. Now, there's a further exclusion I won't get into as an alternative exclusion, 148.24, that if an insured to the prejudice of ICBC settles a tort action or prosecutes a tort action without ICBC's written consent, there isn't an UMP claim. There are other parts of that dealing with what amounts to obtaining that consent, but I won't get into that. But that's sort of a corollary way that ICBC may be able to argue there's no UMP coverage. And other exclusions, and you should look at this, relate to occupants of unlicensed vehicles, depending on knowledge. Secondly, limitations of coverage relating to occupants of stolen vehicles. Thirdly, there's no coverage for hit and run accidents not on a highway. And if the accidents occur in the Yukon, Northwest Territories, or USA, there must be physical contact with the unidentified vehicle. I'll pause here to say, you should also look at uninsured vehicles because sometimes the vehicles are uninsured. So you have to look at part 8 and also part 10 division 1 relating to uninsured vehicles because they may be combined. You may have both an uninsured vehicle and an underinsured motorist. And also an exclusion is there's no liability if the accident jurisdiction bars tort claims, as ICBC seems to do now, except for limited situations. So deductibles, and this is a huge part of the whole scheme. Again, keeping in mind that UMP is last stop or top up insurance by definition. So in the regulation 148.11 as a defined term, there's a long list of deductible amounts which an arbitrator must deduct from either scheduled limits, the basic 1 million, or if there's excess insurance from that limit, or what the arbitrator has awarded. So that includes paid or payable part 7, benefits past and future, third party limits, WC benefits if elected, CPP benefits, EI benefits, LTD benefits. So there's a significant body of arbitration awards on deductibles. I can't cover it, but that's there, and it's summarized in part in chapter 8. On cost, just remember that as a result of an arbitration I did years and years ago for a claimant, the legislation was changed so that the arbitrator can only award party costs. The arbitrator has no authority to order special costs or solicitor and client costs, and arbitration costs and underlying court costs are included amounts in an UMP claim. And unlike third-party limits, which have the costs and interest on top of limits, the costs here are included. So sometimes you have to think, okay, is it going to be worthwhile incurring all these costs when they're included in limits, or the award that is made, or the third-party limits set out in the schedule, or the excess policy. And again, I'd remind you that there are a bunch of arbitration awards pre-June 1st, 2007 on these deductible matters, costs and interest, and ones after June 1st, 2007, which are easier to find than the pre-2007 ones. But Mr. Lee of ICBC seems to be the repository right now, and Alistair can maybe comment on that, but it's philip.lee@icbc.com. And just one area I want to highlight as a complicated legal matter is the definition of insured as a member of a household. I decided an arbitration award years ago on who and who is not a member of a household. Household isn't defined in the regulation, it's defined in part 1, and household means every person ordinarily residing in the same dwelling unit. And that has led to some complicated inquiries factually and legally, and some decisions on that point. And so you've got to look carefully when you're going through the definition of insured. Okay, household members ordinarily resident in the same dwelling unit. What does that include? What if there's a person who goes between two households, and where do they ordinarily reside? Can you have two households, which is what I decided in one case. So those matters are intensely factual and should be front of mind. Definition, insured definition of underinsured motorists in a practitioner's mind. And I'll be happy to answer any questions. Thank you.
I guess I'm next up. My name is Ken Glazner. I'm an arbitrator and mediator for some decades, and my background is set out in my website, including an article dealing with an argument against using the Supreme Court rules in UMP arbitrations. My task today is to deal with the importance of first case management meeting and first procedural orders. Now, let me start by admitting that I'm going to read my material. I don't have the technical skills to have a paper on the screen such that it looks like I'm not reading. Permit me to lay out a bit of a background. The Honorable Robert Armstrong, QC, said, "Arbitration is very different because in court adjudication, you never see the trial judge until the day you finally get to court. The reverse happens in an arbitration in that the arbitrator is there from the beginning. One of the many advantages of domestic arbitration includes flexibility and party control. You have chosen your decision maker, assuming based in part on their background in product knowledge, character, competence, and procedural knowledge. The arbitrator is there ab initio, as opposed to going to court and being forced to accept, as Jerry Geekus QC once said, the parties may prefer arbitration to litigation because they want the comfort of choosing their own decision makers rather than accepting a last-minute assignment of an unknown member of the as yet unspecified specialist judiciary. The initial objective of First Case Managed Conference includes to set the date and number of dates for evidentiary hearing, to decide and agree on a set of rules, to identify appropriate hearing steps, to tailor a process that meets the needs of resolving the dispute. The first procedural meeting, followed by the first procedural order, are essential in resolving a dispute in a just, speedy, and economical determination of the proceedings on its merits. That's a statutory duty. To this end, VANIAC's new rules includes Rule 16 with the provision that the arbitrator convenes the initial procedural conference within 10 days of the appointment. The arbitrator may have received their appointment notice, the notice to arbitrate coupled with the previous court proceedings as in an UMP case, and other documents before sending out their initial invitation to counsel. That initial letter will generally include 1, the initial acceptance subject to the execution of a retainer agreement, an initial proposed agenda, an invitation to counsel to add to that agenda, a venue and time for the initial procedural meeting. The proposed agenda may include, and I'm not putting this in any order of importance, the identification of issues in dispute, procedures to be followed, time periods for steps that will assist the arbitrator to proceed to an efficient and expeditious manner, agreed statement of facts, discovery documents, if any, an application for examination for discovery. Remember, in arbitration, you are not entitled to examination for discovery and will have to make an application to the arbitrator if you don't have consent from opposing counsel. The date of the arbitration hearing, estimate time for the hearing, venue for the hearing, including size of room, court reporter, audio-visual aids, the method by which you are going to deal with the exchange of expert reports, exchange of documents, and here I assume that the arbitrator is up to speed with respect to the new Arbitration Act, which came into force on September the 1st, 2020, and the VANIAC rules, which came into force on the very same day. Direct evidence of facts witnesses is set out in Rule 18 of the VANIAC rules. Common book of documents, agreement as to the nature of closing argument and delivery of case law if necessary. And last, the Rule 19 Vaniax rules, which is commonly referred to as a Redfern request. On occasion, experience and cooperative counsel have already set out in some format a procedural timetable and submit it to the arbitrator. That's most helpful. If the Vaniac rules are to be followed, then the heavy lifting by counsel soon follows after the first meeting, including the application of Section 19 document disclosure. In my experience, counsel lean towards some form of modified form of Supreme Court rules as exhibited in the procedural timetable. But because of two recent decisions, one of our Supreme Court and one of our Court of Appeal, I would caution counsel if they wish to adopt the Supreme Court rules. And to that extent, and let me get the citation, because I think this is now essential. The decision is MECIK, Mekik versus Christy Chan, a decision of Mr. Justice Kent on February the 8th, 2022. The citation is 2022 BCSC 182. And I commend the first 15 paragraphs. That decision cites a decision of our Court of Appeal dated October the 1st, 2021, titled Mercantile Office Systems Private Limited and Bandry versus Worldwide Warranty Life Services INC. And the citation for that is 2021 BCCA 362, in which the court literally sets out the forms for use in civil litigation and its necessity. So if you're going to opt for the Supreme Court rules and not wish to learn the arbitration process, which I suggest you're going to have to learn, particularly in way of disputes are now being directed to arbitration and not to the courts, then you should be cognizant of the pitfalls. Once the meeting is over, which generally takes no more than a half an hour, the arbitrator will circulate procedural order in direction number 1. Because the arbitrator's duties include case management, they will from time to time follow up to ensure counsel are still on track for the hearing date, thus preventing an application for an adjournment. Where counsel are experienced and cooperative, a case from the appointment of the arbitrator to the final decision can easily be met with a time period of 10 months. I just finished a case of that nature where I was appointed in the middle of January 2021. We had 2 case conferences, 2 procedural orders. The case was heard over 6 days at the ending of August with about 10 witnesses, some on Zoom, some in person, including closing argument. And the decision was rendered, I think, on November 1st or November 2nd last year. That was done because of the cooperation, experience, and professional attitude by counsel, both the claimant's counsel and ICBC's counsel. Before closing, I want to direct your attention to a 2-part webinar put on by Vaniac, and it's on its website. It's called Nose to Tail. There are 2 90-minute series in which a number of panelists went through the complete procedure with respect to the Vaniac rules. I think that's all I want to say at this point. I certainly would welcome any questions on first procedural order, problems and complications that come in, further procedural orders, such that during the process, in most cases, cases are settled. Thank you. Mark, over to you.
Again. So I have as well mediated any number of cases. I currently have quite a few actually active arbitrations. My topic is what to expect from your arbitrator, which is a pretty good topic actually, and counsel's role in the arbitration. Ken spoke of an arbitrator having background in the subject matter, character, competence, and procedural knowledge. One of the advantages to arbitrating through VANIAC is that VANIAC maintains a roster of mediators, of arbitrators, mediators as well, but arbitrators who possess all those qualities. So you need not shop around for someone who has a background and has good character, is competent, and has procedural knowledge. You're going to get one of those when they are appointed through the appointment mechanism. In essence, VANIAC has vetted ahead of time the arbitrators for you. I think the first consideration, if I was counsel, the first consideration I would have, or the first expectation I would have of an arbitrator I was about to appoint is the arbitrator available? I have had a few, I've been involved as arbitrator in a few UMP arbitrations where the case has proceeded to there's been a trial date set in the underlying tort claim. The case has proceeded to a certain point. There's an acknowledgement that it will exceed limits, and there's consent to move it into UMP. Counsel sometimes have a block of time set aside. They have their experts lined up for that block of time, and they will come to me saying, we have this UMP case, are you available in this time period? That's not in all cases, but if you do have a block of time where you're set and ready to go for that period, I think that's an inquiry you should make. Availability generally is obviously something to canvass as well. Not related to arbitration, but I remember mediating 2 catastrophic injury claims in one day in northern British Columbia. Got to the end of the day, both cases were resolved. I didn't know any of the counsel involved, and I asked, I think it was plaintiff's counsel, I said, by the way, how did I come to be the chosen one in this case? And the counsel said, well, we asked about 5 or 6 people and you're the only person available. And it was not quite, I was expecting you worked for you did a mediation for my colleague so-and-so and had a good review, so we chose you. So availability, I think, is key. As well, I receive any number of calls from counsel who are looking for an arbitrator and want to know my availability generally. In other words, are you able to hear a 5 to 10 day arbitration in the next 6 months? Or what is your timeline for hearing it? I think those are all considerations for counsel when deciding who should be appointed rather. Ken spoke of the initial pre-hearing conference and touched on some of the things I think are important expectations of the arbitrator. The rules require a pre-hearing conference within 10 days. It's my experience that it's often very, very difficult to pull that off due to people's schedules. However, I do believe that you should expect your arbitrator to hold that conference in a timely manner, even if it can't be within the 10 days. I also think that it is not unreasonable to expect the arbitrator to provide you with guidance and assistance in determining what rules should apply, what rules, and I agree with Ken, I think it's a mistake to holus bolus adopt the Supreme Court rules in an arbitration proceeding. You end up with all sorts of strange things that really have no home in an arbitral proceeding. But I do think it's reasonable to inquire of your arbitrator and to expect them to advise you on what do you think we should do from the point of view of rules, and in particular, what modifications to the VANIAC rules the arbitrator recommends. I also think the arbitrator you should expect your arbitrator to provide insights and direction as to what steps have to be taken prior to the hearing and when to take them. Such things as common book of documents, document agreement, agreed set of statement of facts, and notices to admit and so forth. As I say, I think the arbitrator should be suggesting those things for counsel to consider, in some cases directing them, but certainly suggesting them in the first instance for counsel to consider, and then with the assistance of counsel, establishing a reasonable timeline to get all those things done. After the pre-hearing conference, I also think it's reasonable to expect the arbitrator to follow up. I agree with Ken that in essence, there's an ongoing case management role. And that includes dealing with the milestones that were established for the various steps that had to be taken. But they also include dealing with what would normally be interlocutory matters in a Supreme Court trial. That's where the flexibility of the arbitration process, I think, really shines. You can basically devise a process that's the complexity of which is commensurate with the issue before you. I've dealt with what would be interlocutory matters in any number of ways, ranging from simple telephone discussions between counsel and then issuing a direction through to full-blown submissions and an oral hearing. It all depends on what the issue is that's going to be decided. The beauty of the process, as you've heard, is that it is flexible and can be adapted to deal in the most expeditious way with the issue that's before that needs to be dealt with. One of the other things, and Rose touched on it, I too like getting the expert reports ahead of time. It gets me up the curve, so to speak, ahead of the hearing itself. I also encourage counsel to, prior to the hearing, and to deliver their objections to expert reports prior to the hearing. Those can be dealt with efficiently by the arbitrator prior to the hearing itself. They save all sorts of time and all sorts of money, in that you don't have the expert waiting out in the hallway while you debate their credentials or debate certain paragraphs or pages, as the case may be, of their reports. That can all be dealt with, or often all be dealt with ahead of time. So what should you expect from the arbitrator at the hearing itself? Again, I think we assume correctly that the arbitrator is going to be competent and knowledgeable of the subject matter and of the various procedures that have to be undertaken. I think it's not unreasonable to expect the arbitrator to be flexible in terms of hours of sitting. Again, as we've heard, one of the hallmarks of this process is flexibility. I've started late, I've started early, I've sat late, I've ended early. I've had some witnesses by Zoom, some remote, or some live, and shifted all those things on the fly, so to speak. I think that is a very important part of this process. I think as well, the arbitrator at the hearing has to be flexible as to sometimes a sequence of witnesses. Things change. And again, one of the hallmarks, or one of the real advantages of the process, is that the procedure can change with it. So you're through the hearing. What are the reasonable expectations of the arbitrator at the end of the day? The rules require an award within 60 days. And I don't think it's unreasonable to expect your arbitrator to deliver an award. There's often post-award issues, sometimes surrounding costs, sometimes surrounding deductions. Again, flexibility as to process and dealing with those matters in the most efficient way possible is something that I think falls upon the arbitrator. So that's it from me in terms of expectations of the arbitrator. What's the role of counsel? They say in mediation that process is the domain of the mediator, and content, in other words, what's mediated, is the domain of counsel. I don't think that that translates exactly in arbitration proceedings, but I think it's close. More often than not, the arbitrator will have more experience in UMP matters anyway. Commercial matters are another issue, but in UMP matters, generally speaking, the arbitrator is going to have more experience with the process than counsel will. I think counsel, one of counsel's jobs, if you will, is to make sure that the arbitrator's experience is used to advantage. In other words, if counsel has issues as to how something should proceed or how something should be dealt with, it's incumbent on them to raise it with opposing counsel and the arbitrator. I think counsel as well should, and Ken touched on it, there are a great many steps. I did a hearing last year where I think by the time we measured it out, we'd actually had 9 days of hearing in 7 days due to the periods of time that we sat and so on. But counsel agreed that had it been a trial, it would have been closer to 15 days. And the reason that we managed to get it done in that period of time was there was an enormous effort put forth by counsel to get organized what could be organized ahead of time, narrow the issues in terms of what they were actually fighting about versus what they might want to fight about but decided weren't important to fight about, and as well having any number of issues dealt with by me prior to the hearing. The process allows the parties to do that. It creates an efficiency in the hearing itself, and it strikes me that is one of the most valuable things that counsel can do, is address their minds to what can we do to minimize the time we are before the arbitrator, bearing in mind you've got this flexibility of process ahead of time. The three big things on that front that, in my experience, are: one, issues relating to expert reports; two, admissibility issues generally; and three, certain legal issues that might be dealt with ahead of time that prove that will be important in the hearing itself. So that's it from me. Thank you very much.
All right. Thank you, everyone. If Alistair has any comments that he wishes to make, and maybe this would be an appropriate time, anything that arose in those discussions that you'd like to amplify, while Alistair contemplates that, I'll just mention that one of the questions that came in through the chat function was whether there would be written materials available. This proceeding is being recorded, and it will be made available through our vaniac.org website. But written materials per se are not going to be distributed. But if you're interested in rehearing something or checking out something in closer detail, it will be this presentation will be available on our website via video, and just give us a couple of days for that. Alistair, anything from you?
Thanks, Barry. I'll try and keep it short. Be a bit of a quick hit, so if I'm blunt, forgive me. First place, after reading Chapter 8, Vince is quite right. That's an extremely valuable part of the Claims Practice Manual. Ken's got some articles out there. There's a paucity of written materials on arbitrations and UMP, but they are out there. If you find them, start with those. If you want to go to the icbc.com website, that is where you'll find the decisions that some of the panelists have referred to. Quite right that we've only been posting them, we ICBC, since June, I think it's 2007. That's not for lack of interest in ICBC, but that's because of concerns about confidentiality, what the arbitrators expected, and the rest of it. On the icbc.com website, you put in the search term arbitration decisions, and there they are. Last time I counted, there's 53 up there. My claim to fame is I was counsel on the second and third one. That is a great place for, be you a veteran or a newbie, to start to get some awareness of how decisions are decided. Vince was quite right to hammer home the point that there's been 5 kind of essential changes in the lifetime of Part 10, and you want to be aware of which statutory regime covers your client or if you're acting for ICBC, the date of loss. So that's essential. Those 53 decisions are important. Phil Lee's not a librarian. The provisions of and providing decisions before 2007 is very ad hoc and replete with concerns, but your solid research background is found on the ICBC.com website for post-June 2007 decisions. They aren't anonymized. And keep in mind for your background that the regulation puts the onus on the arbitrator. The arbitrator has a statutory duty to provide an anonymized arbitral decision. So often there's a lag time of sort of 1 to 2 to 3 months. Secondly, to hit hard on the idea that I bring my trial mind to it. You remember Rose's comment earlier on, but I think we're on the same page about this because the pace and the flexibility that all panelists have talked about with arbitrations are key for any counsel to be aware of. I come at this from a counsel perspective. Not just discoveries you want to look into, Ken's quite right and smart to identify for the participants that you do not have a right to a discovery, but I've never had a counsel turn me down or lost an attempt to get it, but also keep in mind lists of documents. Disclosure is key. It's just as essential as if you were in front of the Supreme Court. I also want to hammer home the point about civil rules. Adopting the civil rules generally, I'm not casting aspersions, it's going to sound like it, I'm really not, but it's lazy. You can't do it because you're immediately in violation of it, because we all know the rules of court well. Well, how are you going to be complying with the rules of court about notices of trial, for example, when you're in an arbitration proceeding? But this brings up a slightly subtle point. There's no reason you can't agree with other counsel and get the arbitrator to agree that certain rules you're going to adopt. I want rule 7, I want rule 11, certain specific rules that can speed the process. To build on what Mark and Rose were saying, and in fact, all the panelists were saying about narrowing issues, that's key. 2 things you want to do: keep in mind agreed statement of facts and a version of a notice to admit. That's a way to narrow it down and hammer it down. Last point I'd like to run through is Rose made a point about depositions, American proceedings. You can bring that kind of inventiveness and creativity to this process far easier than you can in front of the Supreme Court because you've got access to the arbitrator, the chosen arbitrator. I've noticed Dennis Quinlan and some other arbitrators refer to AMCs. I love acronyms. That stands for Arbitration Management Conference. You get the expert to do a version of a deposition. You take care of that months before the actual arbitration or even weeks. That may well assist settlement. A number of the panelists mentioned that just as with our Supreme Court, a great deal settles before you actually get all the way. But often there's real confusion or disagreement, honest, sincere disagreement, particularly about what are the deductions. Vince is quite right to hammer home the idea that this is last party insurance. You want to put on your mind as counsel the idea of, think back to your Section 83 experiences, deductions, collateral benefits, that sort of thing. A great deal of that is taken off. And some arbitral proceedings are simply purely about the issue of what is deductible. So those are some off the cuff comments, Barry. I hope assist the participants. Really appreciate being invited to join this group and hope that it was of some use.
Yes, that was very helpful, very quick, but helpful. And again, I think the fact this is being recorded means your comments will likely be referred to. People can go back and check that. A couple of questions have arisen in the chat function. I don't know if our panelists have had a chance to see those. One from Oliver. The question is the import of section 148.1 sub 1 that if a third party has $1 million coverage, which is paid in full, and they claim it as $1 million UMP, there is no entitlement to UMP benefits due to sub G.
Barry, may I comment on that? To say I agree
Please.
with my learned friend Jim Vilvay. If you only have the basic 1 million cover and there's third party limits that are paid, there's no UMP claim after that. There's that the third party limits get deducted from whatever, the limit is 1 million. It's always the lesser of when you look at what you deduct from. So toward judgment, Is it the arbitration award, or are the scheduled limits? Whatever is the lesser. And those claims include, as I try to emphasize, interest, costs, everything. And then you go to the deductibles, and you go down, okay, third-party limits, 1 million, end of claim. And may I add something also to what Alistair was saying, just in terms of rules while I'm thinking about it. Often when we get an arbitration assignment, a deal is already in place, and it's been asked for by ICBC. So in terms of getting ICBC's consent. So the claimant does not have to go and get that unsatisfied judgment. The ICBC says, yes, okay, we'll agree to your settlement, and we'll agree you can go to UMP to get any overage in compensation. But as a requirement, we want you to agree that the arbitration is going to be run under BC Supreme Court rules. And that may be because maybe the tort matter really didn't get far. So there's no exchange of documents, no discoveries, no experts, etc. And I can kind of understand that. But it's often ICBC that's sort of set the requirement of application of the BC Supreme Court rules in the deal they make.
Hop in on that for a second.
Yeah.
I'm seeing less of that than I used to for some reason. I agree it was a de facto for any number of years, and I haven't seen it pop up on the last few cases that as a condition. So perhaps there's I see Alistair's contemplating.
There's certainly a growing awareness because of a variety of people's efforts. First, let's understand that the idea of saying adopt civil rules, there's an assumption, and so far it's been proven true, that there's generally good faith between the parties. I know of no example, for example, where the parties agree to the civil rules and then you have claimants counsel run off to chambers and pretend that they've got a right to do so under the civil rules. My point is that you really technically properly cannot adopt the civil rules as a whole. The reason to proceed that way was to provide some assurance to claimants counsel in the past. I think you'll see a greater and better understanding of it. But the greatest concern for ICBC, and again, speaking just for me, counsel for ICBC, I'm not ICBC, but the reason for in the past, the idea of pushing the civil rules was, look, we have to rely on the idea of proper disclosure, and proper disclosure is what everybody's familiar with under the civil rules. That was the key item. So disclosure, as well as, of course, the expert reports. What I was suggesting to the audience as a whole is that if you're really taking, in my view, and casting no aspersions about past performance, you want to take a look at a buffet approach. There's certain rules you want. It makes no sense to adopt the civil rules as a whole because of, for example, notice of trial provisions and 18 other examples. But I also want to assure the crowd as a whole that nobody was trying to get advantage, and we never had a situation of where claimants counsel tried to take advantage. It was a quick way of quickly making sure everybody was comfortable with the situation, because often in the background, and the panelists understand this even better than me, often there was major timing concerns about what insurers were doing. If you've got a California insurer saying, okay, we will pay out $100,000 even though it's more than PIP, and then claimants counsel turns around and is looking at ICBC for an immediate response. And so a quick and ready agreement that the rules will apply made sense for everybody's purposes. Negotiation, understanding, and awareness are just as important in the world of Part 10 as they are in the Supreme Court. So that's some background for you. But I just wanted to illustrate that really, when you have time to look at it, there's certain elements of the rules that you want and others that have no application towards the world that we're currently talking about.
Thank you. I think Ken has a comment.
Yeah, first of all, I agree with you, Alistair, in those comments. Let me segue into corollary area. We're talking about domestic arbitration, statutory arbitration under the UMP rules, but I see we have 77 participants, and I suspect a number of them are involved in commercial arbitration and other areas, or now becoming involved with the area of arbitration. So the issue is what source material is available out there. And I'm going to recommend a soft covered book. Excuse me, I'm putting it up. It's about 400 pages. It's called A Practitioner's Guide to Commercial Arbitration, edited by Marvin Huberman, who used to practice in Vancouver. It is edited by Irwin Law. It costs about $120. It came out 4 years ago. It has 17 chapters, 15 papers, of course, prepared by Toronto lawyers and 2 prepared by Vancouver lawyers. That is a good guide for anybody who's practicing arbitration, whether they be counsel or the arbitrator. Source material for case law. I'm just going to look over here what I've got here. Commercial Arbitration in Canada by Ludmila Herbst and Ken McEwen. It's an expensive loose leaf. I think I just spent $600 for the update, but it is a great source material. And you can adjust whatever you need for UMP arbitration, but I suspect a number of you out there will be hopefully using arbitration, the VANIAC rules, and expanding your practice in order to ensure that your clients get an efficient process in place. Anyway, that is my comment. The book is very helpful, notwithstanding it's 4 years old.
So Ken, just repeat more slowly the name of the book and then
Sure.
also the loose leaf, the binder that you referred
Sure.
to.
The book, let me put it up here.
Commercial arbitration.
It's called A Practitioner's Guide to Commercial Arbitration, edited by Marvin Huberman. Marvin practices in Toronto, but he's a Vancouver person. Irwin Law, published in 2017. It is what I call a basic and sophisticated, easy to read with loads of precedents on how to practice commercial arbitration.
And
it's inexpensive.
What was the name of the loose leaf, the binder you referred
Okay, let me just, I have to move over to the other side of my office.
to? Sorry to put you on the spot.
Commercial arbitration in Canada, it's loose leaf. Ludmila Herbst, who is very involved with VANIAC, and Ken McEwen are the editors of it. It is at least the Bible I have been going to for a number of years. I don't get a spiff or anything like that by promoting the book, but it's certainly material that you should have readily on hand. There are other books too. Toronto has a book, Brian Casey has a good book too. I use the local one for the best results.
Thanks, Ken. There's a couple of still remaining questions in the chat function. One was following up on a question we discussed already and Vince commented on. And this one says, following up on Oliver's question, if there is a determination at trial that injuries are divisible between 2 MVAs, I think they mean motor vehicle accident there, not motor vehicle act, between 2 MVAs and one MVA is insured and the other is not, does the amount paid on the insured and divisible claim get deducted on the uninsured? Anybody on our panel want to take a stab at that one? Alistair?
I'll be brave. It's not
You are.
It's not legal advice, and I'm not speaking for ICBC, but based on the question in and of itself, if they're truly divisible, then it's difficult to see how you can deduct one from the other. Although the mind races with all kinds of examples of pecuniary damages that you could try and deduct. But I think if I understand the person's question correctly, it is not deducted from the uninsured if it's truly divisible. But like I said, you know, a 5-year call would easily put together scenarios where there's going to be overlap between the pecuniary elements of the claim, even if they're divisible injuries. So it's a, you know, that's a kryptonite question. You know, I mean, the smart answer would be to say nothing, which is probably why nobody else is saying anything. The less smart answer is to say, well, for example, is there or isn't there any kind of effect in any way, shape, or form, even 1%, on the individual's ability and capacity to work in the future? And of course, the hierarchy of the needs and the accidents and the rest of it. So with all those massive caveats, the answer is no, but it's all fact specific. I mean, that's the world we live in. But in a beautiful, true division, no capacity concerns and the rest of it, yeah, it'd be difficult for me to argue that it's deductible. But like I said, in 2 minutes, we're able to come up with scenarios where it would work. So that's probably a deeply unsatisfying answer, but it's a nice college try.
And that is much appreciated. Thank you. Anybody else want to weigh in on that?
I'd put on my no longer a lawyer hat for that one, I think.
Well, if there's a accident, if I'm understanding this correctly, and I'm hesitant to get into it because I don't really understand the premise, I think, to it. But if there's a claim, an accident that's caused by an unidentified motorist or an uninsured vehicle, there are provisions in the Insurance Vehicle Act and in the regulations to deal with that. In other words, there's a concept of the fund, right? That used to be called the fund. It's not that anymore, but there are places to go if an accident is caused by an unidentified vehicle, whatever that is now, Section 24, and then Section 20, I think, is the uninsured vehicle, just off the top of my head. But I mean, that's where you go to figure out what the limit of compensation is for that. So I don't know if it has really anything to do with UMP as such, but I may be missing the point of this question.
There is another question there. Can someone give us guidance on cancellation fees when matters settle? And we've heard already that just like before trial or court-related matters, in arbitration, matters often do settle prior to the hearing. So what happens in terms of cancellation fees?
Well, it's up to the terms of the retainer or the arbitrator. So whatever the arbitrator has as a term of the contract of the retainer in terms of cancellation fee. And I think they vary from arbitrator to arbitrator.
Let me add a point in there that the arbitrator should not rely upon some last minute moment saying he or she's going to charge arbitration fees. It's my practice to set out quite clearly the cancellation fees, particularly in UMP cases, because almost all of my UMP cases I've dealt with settle. And the issue then becomes 2 weeks before the UMP case starting, or a month or 2 months before, I have an opening for 10 days. In my practice, and now that I'm semi-retired, is exclusively arbitration and mediation, and that can't be filled. I mean, I'm supposed to have started a 25-day construction case next week with excellent counsel before me. It's been in the works for 3 years. That, of course, just settled. So one slides into the cancellation fees in that regard. Arbitrators who practice solely as arbitrators and not counsel have great difficulty in filling those slots, unless, of course, the cancellation has occurred a few months beforehand so that those slots can be used for other cases. But it must be in writing. I would refer you to some of the textbooks in England. Redfern and Hunter has a great discussion on that particular point. They call them commitment fees. Anyway, that's my rambling.
Yeah, I send out an agreement that includes a bunch of things, including cancellation policy and cancellation fees at the commencement of the matter. I think it's pretty standard to do that. And I agree with Vince. I understand it varies from arbitrator to arbitrator. The key the key point is I do believe it has to be upfront. And by upfront, I mean known well in advance of when it kicks in.
Barry, I noticed there was a question in the Q&A as well about the use of med arbs in claims.
I'm sorry, I missed that question. Oh, in
Yeah,
the
it's in the Q&A, not in the chat. I have no experience with it, unfortunately. I think it's something that should be used much more. There seems to be a reluctance or hesitation to use med arbs in cases in general. And I think it is a fantastic tool that we should all be using more. But maybe my fellow panelists have got some experience doing it. I think it's a great question because it's something that it's a tool that's out there for us to use that appears to me to be underutilized.
I'll tackle that if I may. On MedArb, I usually include in my opening letter to council, along with the suggested agenda, that I am also available for MedArb. But in saying that, I have certain clauses and protocols that must be agreed to by council if we're going to adopt a MedArb. MedArb is very difficult in the sense that the parties really don't want to disclose in a mediation such that the arbitrator has said his or her mind when they slide into arbitration. My attitude on that is to say to council, look, if I was sitting in a criminal trial as a judge, I would hear a voir dire. And in that voir dire, I would hear evidence upon which I would rule on that voir dire. But after that, I have to discipline myself to clear my mind of anything I've learned in a mediation. And that's the approach I would take. Now, having said that, I don't think I've done more than 2 MedArbs in my entire career on a domestic case. I make it available as a process in order to resolving. I have 4 or 5 paragraphs that deal with protocols, and the parties have to realize that what I do in a mediation is risk management analysis, and what you tell me in a mediation is not evidence. It's material that you're giving to me with respect to assisting resolving the dispute. If it's not settled, what you told me does not exist. So I think you have to take that type of approach. At least that's the approach I take. That's it.
Thank you. Noting that we have a couple of minutes left, anybody else want to comment on that or any other question? I did answer in the chat function a question about the citation for the case that Ken had mentioned, Mekik versus Chan. I put the citation there, and that's from February of this year.
Every
Barry,
day.
could I just comment on what Ken said? And I have very limited experience with med or med arb. I have been a court-appointed arbitrator in certain class action appeals related to the blood cases, but and in that the rules allow for med arb, and so I've done it. But I find in UMP matters, at least the practice seems to be the parties experienced in the area generally pick an experienced UMP mediator, if I can use that expression, to mediate, and then an experienced UMP arbitrator to arbitrate. And I've seen some of us flipping between those rules, so that you may have Mark as a mediator on one and I'm in the arbitrator, and vice versa. Although that's a hypothetical. I don't think that's occurred with Mark and I, but it's occurred with others. So that seems to be the practice. So for whatever reason, the parties don't seem to do it with the same arbitrator.
All right. I'm not seeing any further questions or anybody else wanting to, on our panel, wanting to comment. I will share this. We had a webinar earlier this spring where we talked about a pilot project that ICBC has developed in coordination with VANIAC, Vancouver International Arbitration Center, to offer litigants in personal injury cases that are not UMP-related the option to arbitrate when matters are bumped from trial. So everything's ready to go, and then through no fault of anybody's, there's simply not court time available. ICBC has extended a number of offers under this program, the pilot program that we've developed with ICBC. And I'm pleased to announce that we now have our first case. It's still early days, but a matter has been commenced under this pilot program for personal injury matters as an alternative to the court system. That is not the focus of today's presentation, but it is somewhat related, and I thought I would just share that. And for people that are watching and are not aware of that program, feel free to contact Alice or I'll mention you, or you can contact us at VANIAC, and we'll forward you the appropriate details if you're plaintiff's counsel and you're interested in learning more about that. But that is a program being administered by ICBC, and they will extend offers to arbitrate in the circumstances that I've described. And they're subject to various limits and rules, but those details we can provide you with. With that, I'd like to again thank our panelists for their insightful comments and contributions, and especially all of you, our watching audience, for taking the time to join us today. Don't forget to claim your 1.5 CPD credits, perhaps early next week. It should be available through the Law Society website in the regular course. Wishing you and yours all the best for the rest of the week. Thank you very much.